Welcome everyone to the first day and second session, although there have been some other great things, exciting things going on so far. The CDC eviction moratorium may not be exciting to some people. However, it is definitely impacting our business as we move forward, as we continue to move through the pandemic. So John and Greg, we have our on-site, our business managers from across the country, in addition to all of our regional property managers and all of our leadership throughout the country. So I know this is going to be a great session, and we have lots of great questions that I hope that we get to. But team, we have Greg Brown, he's the SVP of Government Affairs for the National Apartment Association, and John McDermott, who is the General Counsel for the National Apartment Association. And I know that each one of our teams are very involved with their local, state, and some with the National Apartment Association as well. But I would say now, as much as ever, but through the pandemic, the guidance and support and the countless hours and sleepless nights that the National Apartment Association and all of the local affiliates have helped us understand what's going on with the pandemic, with legislation from the CARES Act to, you name it, across the country. The two of you, John and Greg, and NAA have truly been invaluable to us, and not just saying that. So we really appreciate your guidance and look forward to, I know there were some things that were going on this morning with the eviction moratorium, so hopefully we'll get an update on that. But with that, Greg, I'm going to turn it over to you.
Thanks, Margette. Really appreciate the opportunity to be here with all of you today and talk about our favorite thing to do in the world, which is legislative, regulatory, and legal advocacy. I hope that this presentation is interesting to you and gives you some more information that perhaps you didn't have before you showed up today. So, as Margette said, and as you see on the title slide, this is focused on the eviction moratorium that was issued by the CDC back in September. I want to start out, though, with a little bit of a big picture, just for a couple of minutes, give you a little bit of the broader context, and then we'll dig right into the moratorium. And that's when John can give you the latest and greatest information about what has happened with our litigation over the order. So this is a quick timeline we put together to show you where we have been since the pandemic started. This, as you can see, starts off in March of this year when the pandemic was first declared, and takes you all the way through where we are now to see all the things that have happened. Now, what I'm trying to show here is that you had the pandemic declared, you had the CARES Act, which was the most significant piece of responsive legislation to the pandemic that affected our industry. There were two bills that occurred before the CARES Act, but those were less related to us and more related to employment and some business relief. But the CARES Act was where you saw that first eviction moratorium that ran from essentially the beginning of April through the end of July. Then you went through a couple of months where you didn't see a whole lot of activity on Capitol Hill until you got to the end of May, where you had the first HEROES bill, which was a very large Democratic piece of legislation that covered all different areas of the pandemic and the federal government response. So that was both dollars for individuals to carry them through the economic displacement from the pandemic. There were some housing specific things, including rental assistance, and another moratorium, an extension of the CARES Act moratorium for 12 months and covering all rental housing. As you may recall, the CARES Act only applied to rental housing that had a federally backed mortgage. So that would be Fannie Mae, Freddie Mac, the Veterans Administration, agricultural loans, those kinds of things. So the next big item you see on there is that the CARES Act eviction moratorium expired at the end of July. And we had about a month of sort of this weird dead zone between that moratorium and whatever was going to happen next. And then you had the beginning of September, and you see the CDC order was released by the administration, which shut down all evictions through the end of the year. Our lawsuit over that order was filed a mere couple of weeks later and has been in play ever since. And then you had just a few weeks back, HEROES 2, which was the next biggest piece of legislation. It was essentially the same as HEROES 1, but reduced by about $1 trillion, only 2.2 trillion, 2.4 trillion. So not really real money, but almost real money. And then, so that was also a Democratic bill, essentially another negotiating tactic for the House Democrats and Senate Democrats with the administration and Senate Republicans. Then you had the release of the CDC frequently asked questions, which sought to clarify some of the things in the order. And that brings you up to just today, which was when our litigation was first heard by a judge, and in which John was participating. So you're going to hear from him about that shortly. So throughout this entire period, you see at the bottom, this is when our advocacy was taking place at NAA. We had an enormous number of grassroots folks active, our own lobbying team active, and a lot of other folks trying to get the Congress to do the right thing, to stop the moratoriums after the CARES Act, and to implement some rental assistance to help our residents make their payments and help the owners stay whole throughout this process. And what comes next is anybody's guess, and we'll talk about that in just a second. I wanted to give you a sense of the scale of what we're talking about in terms of this federal response. Now we're getting into some real money. We're talking $11.5 trillion that has been authorized to respond to the COVID pandemic. Now that includes Federal Reserve money. It includes directly money appropriated through the legislative process. It includes administrative actions. And I should say that includes loans. It's not all dollars on the street. Some of that is just authorizing lending money to businesses to keep them functioning through the pandemic and the economic displacement. As of just a few weeks ago, we've committed or dispersed about $5 trillion of that. There is still a lot of loan authority left out there, and there's still about $300 billion of actual cash that has not been spent in some other programs. So this gives you a sense of the scale of this response and how much money really has been put towards it. Now, of course, we get to the guts of this presentation, and that's the CDC order, which I'm going to turn over to John to walk us through.
Okay, well, good morning, Team Lincoln. Greg and I are happy to be here. Margette, thank you for your very kind introductory remarks. I'd like to think that it's being recorded so that we could play from my wife, Pat, that I'm actually invaluable at something. That'd be great.
It is being recorded. I'll share.
Okay, all right. There are a couple of, I'm not going to try and turn this into a too dry a legal analysis, but just kind of the basics so you can sort out what the rules are. In our Constitution, in the Bill of Rights, the 10th Amendment says that any powers that are not granted to the federal government are reserved to the states. So what we're talking about here is a federal government action by an agency of that government that was created by the Congress. So that's very different than the eviction moratoriums that have been enacted by a number of governors around the country. Any effort to overturn a governor's decision in a time of emergency in the courts, that's always going to be doomed to failure. The case, the order itself, from as we all know, an agency that was created to deal with public health issues, not real estate issues. And so oddly, this didn't come out of HUD, which you'd think, well, yeah, they know, you can get an argument on it, but in terms of how much they know about housing, but certainly the CDC knows nothing about housing. So
Sure.
Nobody believes that on the merits, the CDC came up with this order on itself. We think it was generated either by some lower level person in the campaign or perhaps in the White House. So the chronology is that Greg had the list of the dates. This is how we spent our Labor Day weekend. The CDC order was issued on Friday. The Brown lawsuit, which we later joined, was filed in Atlanta on the 14th, just 10 days later. Greg was then meeting with various real estate coalitions to say, how do we react to this? How do we respond to this? And that included, Greg, fill me in if I missed something, it included the home builders, the realtors, our friends over at NMHC, different groups. And rather than act in a in the coalition that they ordinarily act in, everybody sort of went off. They said they were going to go off in their own directions. And then following that, Greg and some members met, ordinarily we would say met at the White House, but he was at the White House any more than any of you are here with us. And then I started talking to the Justice Department lawyers who were representing the case, representing the government in the case. And at that time, I suggested as a solution to this would be if the government was willing to change its definition of eviction. And I don't want to assume that everyone on the call has read the order in its entirety. But the chief problem, one of the problems with the CDC order was that it defined eviction in an incredibly broad way. It said if you take any action that could result in the eviction of a tenant.
Or that resulted in them to be homeless, right? So it wasn't even specifically eviction, which was one of our first questions.
Right, right. So I said that here's the big problem is that you've got the definition way too broadly. So way too broadly. So Greg, could you go to the slide that says what does the order limit? The one I think before this one?
The one before, yeah.
Yeah, that one. Okay. So on here, the covered person is interesting because they said a covered person is someone who fills out one of these declarations. And again, not to get too dry, but I don't know if people on the call have ever been to a courthouse while a judge, or in Texas, I think you have justices of the peace, but to go where a judge is hearing the landlord-tenant calendar. Usually what it consists of, pretty consistently around the country, is the judge, the clerk, and the lawyer for the property management company. In some cases, you don't need lawyers, but in most cases, you do. And that's it. And a case is called, and the lawyer asks for judgment because the tenant isn't there. And the dockets tend to move fairly quickly. The lawyers will have as many as 50 cases in a given day that they'll run through there because the tenants. So when it says it puts the onus on the resident, that meant they had to show up with their declarations. So this order comes out, as I said, just before Labor Day weekend, and the property management world goes crazy because lawyers around the country, this is going to come as a big surprise to some of you, reach vastly different conclusions about what their clients should do in response to the order. There are some that were saying, oh, we don't care. It's, they have to, we'll see whether they show up in court and we can talk to them about the declarations. The other side of it was, oh no, we can't even send a letter about a deficiency, a notice to quit letter as it's known in a lot of jurisdictions, because under the definition of evictions, according to the CDC, an eviction means take any action. And so some people were interpreting it so broadly that you couldn't even write the letter. So it was fairly chaotic. Okay, next slide, please. And these are all, and by the way, Greg gets credit for all these slides because, but the ones I'd like to talk to, on the point I was just making, is the one in the lower right corner, the inconsistent judicial interpretation. So the first out of the box, we had the inconsistent legal interpretation by landlord-tenant lawyers around the country, and then different courts started issuing, because before they got to be judges, they were still lawyers, and they're arguing about it as well. And they're saying, no, we're not going to put any of those cases on our docket. Others are saying, yeah, we can keep going ahead. State Supreme Courts got involved. But it was just a terrible hash around the country of all sorts of different results. And here at the National Apartment Association, we're being asked, well, what do you advise us to do? And CDC's order had been a little more coherent in the first place. We would have avoided a lot of this trouble. Then, next slide, please, Greg. Then,
So, John, the FAQs helped, and obviously to your point, with Greg's actions and not physically in person, I'm sure you guys have been on more Zoom calls than I or anyone else on this call have been on. But with the things that the two of you were doing in conjunction with NAA and other associations across the country, you guys helped to get some of the FAQs out, right? And this is where some of the outstanding questions have been answered. And to your point, we operate in 30 plus states across the country that have their own law. And you had judges and justices of the peace in different places giving guidance to business managers or to people on site and kind of interpreting things in their own way. So leading into the FAQs, this is really helpful. So walk us through this.
Sure. Well, I noticed that we've only answered half of the questions that we.
Hey, better than where we were. We're getting there.
But the answers that are up there are, that is correct. Can housing providers, the second one, can the housing providers require proof to support the residence declaration? Yes, my view of this is always that a residence declaration is just like any other piece of evidence that would be introduced at any type of trial. And what would happen is that the resident would, here's my declaration, and they would be subject to cross-examination by it. But that's kind of yeah, you can require proof, but think about the resources that your lawyers around the country, Margette, have when they go in with their 50 cases for that day. They've got no information other than the account of, what's the amount that's due, when the last rent payment was made,
right,
and maybe a copy of the lease. So yeah, technically you can require proof, and yes, it's very similar to the following question. You can contest the validity of the declarations, but it's unrealistic to think that now you'd call your private investigator to challenge the declaration because you have all those resources. You don't. They don't. So I think on a practical basis, if a tenant shows up with a declaration that says they've been trying to pay the rent and do this or that, I mean, it'll be accepted by the courts. And the last question was, are evictions for holdover tenancies, non-renewals, and termination notices exempt? The answer to that is no. Business as usual. So now we get into, next slide, please, Greg. So this is a curious thing. You remember at the beginning, I said, this is a federal agency that issues an order. And so the question becomes, does the CDC have authority to issue that order? And they only have the authority to do it if that authority was given to it by the Congress when it was created. And so this case, the Brown et al. Means and others in Latin, and among the others is the National Apartment Association. This is the case that we joined in Atlanta. And it's a challenge to the CDC's authority to do that. So after a month goes by, we get this curious thing, not just from the CDC, but now the Justice Department and HUD join in, and HHS join in. And they issue a document that's called Frequently Asked Questions. And in the normal world, it doesn't really work like this. In the normal world, an agency would issue an order and it might amend the order. But it would still be the order. Now, the frequently asked questions, it's almost like a press release saying, you know what? We didn't really mean, when we said evictions was action, we didn't really mean that. Maybe we could clear that up. And it just means that, yeah, you can go ahead and file in court and do everything you want. Just don't kick anybody out on the street. That's a lightning fast summary of what the FAQs are about.
Right, which to that point was extremely helpful to our team. So we can still move forward business as usual to the point that we're not evicting them should they provide us with a declaration.
Right.
But before they were released, our interpretation was definitely more on the conservative side, not wanting to be targeted for a lawsuit, not wanting to break the law, and not moving forward with those.
So this morning, we had a court hearing in front of Judge Boulay in Atlanta, Georgia, over whether the judge would be willing to issue something called a preliminary injunction. And these are rarely issued for a whole bunch of reasons that I'm not going to bore you with today. But essentially what it is that you get to win your case before you get to the trial. You're asking the judge to accelerate the most important ruling by saying, okay, CDC, you can't enforce this order. Stop it right now, even before the trial would take place. So today, for 90 minutes, two lawyers, one representing the government and one representing us and the other plaintiffs, argued back and forth before the judge, who then said, thanks a lot, and declared, then adjourned his court. No indication about when he's going to rule. No indication about, although you think, hopefully within the week, since the clock is ticking towards the December 31st expiration of the original order. But my guess is that he'll probably deny the motion. The case will continue. But as Margette, as you were saying before, we really got a lot of what we needed from the frequently asked questions. The only evictions that are not going to happen, like if as I said, was the vacant courtroom scenario where the tenants don't show up, those tenants can be evicted because they're not covered persons. So the only people who are going to be protected by the order will be tenants who show up for their hearings with their declarations, and all the other cases will proceed as you're used to having eviction cases proceed. So to quote an old Rolling Stones song, you can't always get what you want, but if you try, sometimes you get what you need. And I think that's what the facts are, the frequently asked questions are giving us. That's it, Greg. Go ahead. Rolling it over to you.
Okay, thanks, John. So we have one question in the chat about some folks have judges who are refusing to hear cases, and John, I would assume your answer there would be, of course, that they still have that right if they choose to. They're going to implement how they see fit on the ground. Is that correct?
Right. Some of the judges are refusing to hear cases because their courts or their state Supreme Courts have, after the first order, said this is how we're going to treat that. The courts are in the process, like Arizona just did it a couple of days ago, where they reopened the courts to evictions where they had been closed down initially. So we're getting, it's not a surprise that judges aren't hearing cases, Cynthia, but it's going to vary as they get more comfortable going back to their normal dockets.
And that's a challenge. Cynthia, you're identifying a challenge that has existed since this pandemic started, which is you have overlapping, interacting, and sometimes conflicting regulatory or legislative actions by the federal government versus state and local governments. And sometimes it can be difficult to sort them out, and ultimately judges make their own decisions, how as they see fit. So it is a very messy, untidy process. Sometimes you'd rather have the federal government establish something for everybody and just so you have one set of rules. Other times you'd prefer it at your state and local level because you have more opportunity to influence the outcome of that process. It's a very messy system. So, and speaking of complete messes, let's talk about the legislative process around COVID relief. If you remember back to that timeline I put up before, for about almost 5 months, you had no agreement and very little activity on one half of the Congress around relief. So when the Democrats, when Congress itself passed the CARES Act, that was the last of the bipartisan efforts to address this pandemic legislatively. The House passed its bill, and by its own admission, it was a very wish list type of bill. They threw everything they could think of in there, many things unrelated to COVID. So it was a non-starter from the word go, but it was their effort to start negotiations. Meanwhile, in the Senate Republicans didn't really want to engage on any more legislation until they absolutely had to. Their viewpoint was, we just spent several $1 trillion on the CARES Act and some other bills. Why do we need to spend more money now? Well, that was fine until we got into late June, early July, when we had a resurge of cases. You had the economic situation was not improving. There's a lot of pressure building up to do more things legislatively, but Senate Republicans still felt like it was better to see how the money we had spent worked out before we spend another pile of money. But the dynamic between all the parties is what is really challenging here, because you basically have a three-sided conversation. Well, you have a two-sided conversation at the moment. You have the Speaker of the House, Nancy Pelosi. You have Treasury Secretary Stephen Mnuchin, you see there in the middle with the glasses, and you have Mark Meadows, the President's Chief of Staff, on the far left. Those are really the primary negotiating parties. Now, Nancy Pelosi essentially is proxy for Chuck Schumer, who's the gentleman in the lower half, the small picture. He's the minority leader in the Senate. She's speaking for him when she negotiates with Mr. Mnuchin because they're of the same party. And then the gentleman in the top half of that little minor section in the middle is the majority leader of the Senate, Mitch McConnell from Kentucky. And he has really played sort of a sideline role in this conversation, letting the administration do the negotiations with the House Democrats to try to come to a deal. And as you all have read, they have not been able to do that. And since they started talking in, say, May to today, today is the deadline for having a deal be struck before the election. I characterize this entire process as a dumpster fire rolling down a flooding river. And
best slide in the world.
It is the best slide in the world because it really represents where we're at here. It seems ludicrous to all observers on the outside is that we cannot come to an agreement on this deal to help the American people, because speaking parochially, we have residents, we have owners, small, medium, and large, who are suffering right now and need resources to help pay their bills, help residents pay their bills, et cetera. Not to mention all the other things we need to worry about as it relates to COVID, testing, PPE, all this stuff. And for some reason, the Congress can't manage to get its act together with the administration and come to an agreement. Now, there's probably a healthy dose of politics going on right now around the election. Shocker that would be the case. I can't imagine. But it is the reality that you have the president who has not spoken with the Speaker of the House in a year, has no relationship with her except through tweets and through, and the same for her. Her relationship with him is with media interviews. So they don't have a relationship. So she negotiates with the Treasury Secretary, and the election looms. And there's so much at stake for both sides that the incentives are greater for them not to do anything before the election, essentially because they don't want to give each other a victory. The Speaker doesn't want to give the president something that makes him look great and saving the nation with a big legislative package. And the president doesn't want the Democrats to get any credit for anything that they do on COVID. So it just turns into a real messy situation. Add on to that the president and the Senate Republicans are not necessarily in the same place. Senate Republicans are very opposed to spending multiple more trillions of dollars on COVID relief. The president has indicated more recently that he's fine with spending 2.2 or even greater trillions of dollars on relief. And Republicans are now balking on that. They perhaps would not even bring up a bill on the floor of the Senate if it was in that amount, because they couldn't get any Republicans to support it. So the chances, we'll find out by the end of today, but the chances that we have a bill passed before the election are pretty slim. And those of us that spend all day, every day on this kind of stuff in Washington are highly cynical and believe this is all just kabuki theater, so everybody can walk away saying, we did our best, the other people stink, and we're the good guys and they're the bad guys. So what does that mean? So then we look at the post-election outlook. So the period following an election before the installation of a new president potentially or a new Congress is called the lame duck. It is, my cute little picture that I put in there. It's that weird period where the incentives completely change for everybody involved. So Democrats, 99% chance are going to keep the House. Democrats may take control of the Senate, depending on how a lot of these races go. And the president may or may not be elected. The outcome of those things will change what people feel like doing in a lame duck. So the president loses. Will he be interested in signing a big COVID relief legislative product before he leaves office in January? It's a very good open question. If the Republicans lose control of the Senate, will they be interested in doing the same thing? If the Democrats don't take control of the Senate, what will they be interested in doing? And what will Nancy Pelosi want to do in terms of giving victories to either a lame duck president, or a Senate Republican majority about to be in the minority? So there's an even chance that they will do nothing until 2021. This is called kicking the can down the road, as you all know, if you've heard it 1,000 times. But it really applies here, because if you're Senate Republicans and you're the president, and if they both lose, their opinion may be, you know what, Democrats, you're going to be in charge. You deal with it when Mr. Biden is sworn in and when you officially take over the Senate. So you look at a situation where no legislation until after Mr. Biden is sworn in, and they will write the bill that they want, knowing full well that they will have a decent chance of getting that bill passed in the new year, and that's what they'll do. That's just one of several different scenarios that could happen. So you're kind of wondering to see what will happen next. Is a really good question, and it depends on the outcome of the election. Now, as you probably all know, we don't know when the election will be decided. If you're in Georgia, you are almost assured, barring a very extraordinary event, almost assured a runoff election for one of your Senate seats that won't be done until January. So you're not going to know who is is it Senator Loeffler? Is it Senator Collins? Is it the Democratic gentleman whose name I'm now forgetting? Who is going to be in that seat? And that could determine who wins who's in the majority in the United States Senate. So there's a lot of things that are up in the air here. And for our part, all we're doing as the apartment industry is saying, look, we don't care what your incentives are. We have people trying to pay bills, and if the residents can't pay, then we can't pay. And we're not going to carry the weight for everybody else's problems by just taking another eviction moratorium with no way of keeping an owner whole, because that seems to be what the prevailing view is amongst a number of people in Congress, that landlords can afford it, so we'll put it on their shoulders and we'll sort it out later. And that's unacceptable. So our message continues to be to whoever is in charge: rental assistance, the most robust rental assistance program you can come up with. Robust meaning a lot of money, 50, 75, $100 billion that can go out there and help people keep paying their rent throughout the remainder of this economic displacement, so that owners are kept whole at the same time. And certainly we do not want to see any more eviction moratoriums. Margette asked me to share one other item here, and I'm going to really see if this works in terms of being live. But this is a screenshot of a map that we have on our website in the COVID-19 section of naahq.org. Let's see if it actually works, and it'll take me to the live page.
And it is for the Lincoln team. We do have a link to this on our Knowledge Center, and we'll make sure and follow up that you guys get this as well, so you know where to look. Go ahead, Greg.
So basically, what you have here is a state-by-state breakdown of everything that's happening in the states.
Hey, Greg.
Yep.
Your the audio is a little. Can you guys hear me? Okay.
I can.
Yeah, I can hear you. Can you not hear me?
Yep, your audio is a little off for some reason. So if you'll go back to the website, I'll tell everyone about it, if that's okay. I'm not sure what happened with your audio.
You can't hear me now? Okay, hold on.
Just a little garbled.
It sounds like you're underwater. So,
Margette.
yep. Can you go back to the website?
I can't, shoot, I can't see it now. Let's try again.
There we go. Perfect. So on the National Apartment Association website, as Greg mentioned, it's in their COVID-19 guidance. And I mentioned this in the beginning, but clearly there are tons of rules, regulations, all of those kinds of things across the country, and not just legislatively as it pertains to the operations of your property, but also where we require to wear masks. Now, Lincoln, we all wear masks, but where is it required? What are the different regulations, local and state, for each one of you where your property is located as it pertains to opening back up? The percent of people that can be in a certain space, whether that's a fitness center or things like that. So all of that can be found on the NAA website, and they're doing a really good job of keeping things updated. So as soon as something's updated, it's being reflected. At least we've tested it a couple of times, and you guys, it's being reflective. Someone just asked what the difference in the colors is on the map. The color coding is just the regions for the National Apartment Association. So it doesn't have anything to do with opening or testing or any of those kinds of things, right?
Margette, can you hear me now?
It's still, you sound like you're underwater. I don't know what happened.
Happened either. I apologize. Go ahead.
We do have quite a few questions. And Greg, let's see, we have less than 10 minutes left, and I think that quite a few of these questions will probably be good for us to do some FAQs later and get them back out to the team. But there are a few of them. So John, this goes to, this is from an anonymous attendee. They didn't sign in. A few of the anonymous questions, I need to know who you are because where you're located matters. But just to confirm, I'm managing 2 properties with 2 different lawyers for each property. When I ask questions in regards to residents who have past due balances in which we filed in court in February, so these are people that they had past due balances earlier this year. Sounds like they're probably still living in the properties, but we're getting 2 different answers from the 2 different attorneys. Just to confirm, I can move forward with the eviction proceedings prior to COVID, as one particular resident now has over a $13,000 balance with no effort to pay anything. So I'm going to start off the answer. It depends on where you're located. So that's one. If the 2 properties are in the same city and county, we need to connect with the attorneys and determine why we're getting different answers. If they're not in the same city and or county, it's possible that there are different, that makes sense that you may be getting different answers. But John, do you have anything to add to that question?
I do. So on a serious note, you remember what I was saying about how the order itself from the CDC, that's still in place. To have frequently asked questions has no legal authority one way or the other. But and rather than cleanly amend the order, they came up with the frequently asked questions. So it's sort of like a wink and a nod, but you can go ahead and do these things. But to get specific about the dilemma that you're in, getting 2 different attorneys and 2 different opinions, if after reading the frequently asked questions, one attorney is still saying that you can't do anything, I'd probably fire that lawyer.
Thanks, John.
Yeah, you're welcome.
Gosh, I don't even know where to start with so many of these questions. This is this is actually a great question. I think we can lead with this one. So what about, how does the CDC eviction moratorium pertain to CARES and HUD-backed mortgages, and does that still matter? Greg, let's see if we have you back.
Yeah, can you hear me now?
Yep, we got you.
Okay, good. Sorry about that, mysteries of
Okay.
technology. So, and John should weigh in here as well, but the difference is the CARES Act only applied to federally backed mortgages, as I said. CDC applies to everything, with the only limitations being based on income. So if you made up to a certain, there are specific income limitations that for whom the protection applies. Everybody else above those income, I believe it's 99,000 for an individual and 198,000 for a couple, which is, and John might agree, I hope he agrees with this, but that sort of undermines the overall argument the CDC made, which is that it's important to enact this moratorium to prevent the spread of COVID. Apparently, it's only important to enact a moratorium to end the spread of COVID up to certain people who make certain amounts of money, not everybody, or else you would have applied it to everybody. But setting that aside, that's the difference. The CARES Act only applied to federally backed mortgages. CDC order applies to everybody, with the exception of these income limitations.
Right.
Yeah, Greg, you nailed it, as usual.
So this is a great question. Does this mean that we can, this is from Christy Ballard, does this mean that we can file the eviction even if a declaration has been provided to the community? So that's question one. And then there's a follow-up to it, which is an interesting part. So the answer to that is yes. The declaration has to accompany, you have to submit that, as John has said, essentially like an exhibit to the eviction. So it's our responsibility, one, to make sure that the declaration is submitted with the eviction, and two, to make sure that we don't evict that person until January 1st. But her part B to that question is, what if they don't show up in court? Can they still be evicted?
Well, the answer is yes, they could be evicted, but that would mean that the judge who's sitting in the courtroom doesn't think much of the declaration.
Right.
And just doesn't give it credibility to stay in eviction order. Doesn't mean the judge is going to do that.
Right.
And in some cases, Margette, I point out that different management companies, these are internal business decisions, will decide what to do when a tenant comes up with a declaration, gives it to the company as opposed to exhibit in court. Some companies have chosen to give those persons a pass. But to answer Christie's question, yes, they could still be evicted. There's no guarantee they would be.
Right. And so Lincoln, John, to your point, Lincoln's perspective on that, and granted, every case is different. So we are tracking 100% of our evictions, which we do anyway, but we're tracking them a little bit differently today. We are tracking 100% of all of the declarations that we get in. And at this point, our direction is to file for eviction. If we've received a declaration, we can go ahead and move forward, but it's our responsibility to attach that declaration. And then unless there are some unforeseen circumstances, that resident cannot be evicted until January 1st. If a judge happens to want to process it, different conversation, and that's where we want to make sure that we always have legal counsel engaged and involved in every eviction. This is a good question, and I think, so by giving the resident a copy of the declaration along with their 30-day notice, or 3-day or 10-day or 21-day or 60-day or 90-day, depending upon where you are across the country, are we not giving them the tool to defeat our goal, which clearly our goal is to get them to pay their rent? Our perspective, and again, Lincoln is definitely being conservative along these lines, but people have heard about the CDC eviction moratorium. They know that it's out there. One school of thought, and in providing it to them with their notice, which is what our recommendation is across the country. And and that we're consistent at each property when we're doing this, is that when the judge sees it, it will be seen, we gave the resident all the tools. So the judge may see it as an act of goodwill. It also is just clarifying and clearing things up if they've been misinformed about the declaration itself. But John and Greg, I'd love your thoughts on that, on providing that declaration when we provide them with their notice to vacate or notice to quit.
Go ahead, John.
Okay, from a courtroom presentation standpoint, it's a very smart thing to do, because then you're able to demonstrate to the judge how reasonable the company has been.
Yeah, I would agree with that. I think trying to pretend like it doesn't exist, it's going to be uncovered anyways. When you get to the court, the judge is going to know it's out there, and if you didn't do the right thing, as John described, it's just going to make you look bad. It's just smart to just get it done ahead of time and put it on the table. It's not going to change the basics of your strategy, but it's just better from a, certainly impression in front of the judge and a PR perspective, I suppose, for lack of a better description.
Gosh, so many good questions. What if a resident has a change in their income since submitting the original declaration? I'm not sure that we would, I feel like I need more on that one. That goes back to proof, right? So we're asking.
It does go back to proof. And let's say there's been a time lag between the court hearing and the time that the declaration was signed. And a fairly normal question that would come up would be, the judge would have the declaration and say, is this still true and correct? And at that point, they'd have to make any changes that have occurred since the original one was signed. I don't believe that there is a requirement that they fill out another declaration as of the day they appear in court.
Okay. Ooh, they're great questions, you guys. Can we just send all of these to the CDC, the federal government, let them know how confusing this is for everybody, including the courts, right?
Margette, I would say, please do send them to us, because I can't, I don't know that we can answer every single one of them, because some of them are so scenario specific, I would assume, but I do think it helps us understand how this is impacting people on the ground, which is so important to our advocacy effort. That meeting that we had with the White House included, it wasn't just us at NAA, it was members, including Mike Holmes, our chairman, and a representative from one of our national member firms, to bring the perspective from the ground. And that's how you get what you need. You need to have the real information. So yeah, share all those questions with us. It'd be very helpful. Okay,
great. So our team that's on, we're going to compile all of the questions. There are a number of people that have sent in questions as an anonymous attendee. It's helpful if we have your city and state that you're located in, because we'll be able to answer some of the questions, because they'll be a little bit more specific. However, Greg, to your point, we'll compile all of the questions that we're getting, not necessarily looking for specific answers from you guys. If you've got them, great, but more importantly, for you to share and kind of use in your arsenal of things, if you will. We've officially gone over time a little bit. I don't know if there are any parting words or any additional things. Again, quite a few questions we didn't get to. So Lincoln team, we will get you answers along with our FAQs, but we'll get specific answers to each one of these. But John and Greg, any parting words to leave the team with?
Well, I've got this. Greg and I were both very happy to participate in this today, because Lincoln is such a valued company member within the NAA network, and we were, happy for the opportunity.
Thanks, guys.
Yeah, I would certainly echo that, and I would also say, and I'd be a bad advocate lobbyist if I didn't, that the more you're engaged in not only this discussion, but engaged with people that make decisions, the better off the industry will be. I always tell people that I get paid to do this, and members of Congress and administrative people in the White House, people, they all know that. But when they hear from you, the constituents, the people who actually cast votes, employ people, work with residents, that's the voice that makes a difference in everything that we do. So if you want to up your participation in that effort and share your story or share your perspective, you can contact me or anybody else on our team, and we'll show you exactly how to do that. That's what makes the difference at the end of the day in this work, not just what I say, but what you bring to the table. So please, if you're interested, let us know. We'd love to bring you into the process.
Awesome. Thank you. Thanks for that, Greg. I think that's the perfect way to end. And it's like our industry has really come together through the pandemic and through all of this. And I don't know that there are a lot of other industries outside of the multifamily industry that could really say that. One big happy family with Lincoln, but more importantly, one big family, happy family in the multifamily industry. So thank you guys for all you do. Thanks for joining. I hope that you're able to join some of the other sessions. We've got Ben Saunders and a number of other people coming up. So I'm sure you're busy, but if you can pop in from time to time, I think you would enjoy it.
Thanks, Margette.
Thanks, guys. Bye, guys.
Okay.
Bye-bye.